4. The rights of Englishmen and the rights of man. In primitive law the end is simply to keep the peace. The legal order is a peaceable order at whatever cost, and in consequence whatever serves to avert private vengeance and prevent private war is an instrument of justice. In its beginning law is no more than a body of rules by which controversies are adjusted peaceably. At first, therefore, it attempts nothing more than to furnish the injured a substitute for revenge. Where modern law thinks of compensation for an injury, primitive law thought of composition for the desire to be avenged. Thus the original Roman law dealt with injury to the person under the head of insult. The earliest of the Anglo-Saxon laws provided twofold payment where a bruise was not covered by the clothes and so subjected the victim to chafing and increased his desire to be revenged. The Salic law gave double composition to the Frank, accustomed to right his own wrongs, as compared with the Roman, trained for generations to adjust his controversies in court. Greek philosophy and Roman law soon got beyond the crude conception of primitive law and gave us in its place an idea of the legal order as a device to preserve the social status quo, to keep each man in his appointed groove and thus prevent the friction with his fellows which the older conception sought only to mitigate. Thus in Plato's ideal state every member of the community is to be assigned to the class for which he proves to be best fitted, then the law is to keep him there, and so, it was conceived, a perfect harmony and unity will characterize both the state and every person in it. To Aristotle also, rights, that is interests to be protected by law, existed only between those who were free and equal. The law was in the first instance to take account of relations of inequality in which individuals were treated according to their worth. Then, each being in his proper place, the law would keep him there and would preserve among equals a unanimity in which there would be no violation of mutual rights. The well-known exhortation in which St. Paul calls upon everyone to exert himself to do his duty in the class in which he finds himself, brings out this same idea. Roman legal genius gave practical effect to this conception of justice as a preservation of the social status quo by conceiving it to be the province of the state to define and protect the interests and powers of action which in their aggregate make up the legal personality of the individual. As laid down in the Institutes of Justinian, the precepts of law are three: to live honorably, not to injure another, to give to everyone his due. What the interests of another are which one is not to injure, what constitutes anyone's due which is to be given him, are questions left to the traditional and authoritative social organization. In other words, we have here the Greek idea of the end of the legal system. The idea that it exists to maintain harmoniously the existing social order. In the Middle Ages Germanic law brought back for a time the primitive conception of merely keeping the peace and the primitive institutions of buying off vengeance, of a tariff of compositions and of private war. But as the authority of Justinian in law and of Aristotle in philosophy came to be accepted, this conception of justice gave way to the classical idea of preservation of the social status quo, which, indeed, had behind it not merely Aristotle and the Roman law but the unassailable authority of more than one text of Scripture. Hence in the Middle Ages, as in antiquity, the idea of a device to keep the peace is succeeded by the idea of a device to maintain the social status quo. This conception of the end of law was not questioned till the Reformation. Then the appeal to reason against authority led to a new conception in philosophy, in theology, in politics and ultimately in legal theory, as a result of which the legal order came to be thought of as a device to secure a maximum of individual self-assertion. The beginnings of the change are in philosophy, in the attempt to sustain authority by reason. But the Middle Ages added nothing to the juristic theory of the end of law and only prepared the way, through philosophy, for the new conception which developed in the 17th century. We commonly fix the date of the new era in jurisprudence by the appearance of the great work of Grotius in 1625. As he and those who followed him expounded the new doctrine, it had two sides. On the one hand there was a theory of limitations upon human activities imposed by reason in view of human nature. On the other hand there was a theory of moral qualities inherent in human beings, or natural rights, demonstrated by reason as deductions from human nature. The first had been worked out by those who went before Grotius, especially the Spanish jurist theologians of the preceding century. They had sought to combine the newer ideas of the political order with the older ideas of the unity of law as eternal verity rather than state enactment. Accordingly, in developing the conception of unity of the law as a universal and eternal body of principles, they thought of restraints upon states, of certain limits to their activities which they could not overpass, so that in international law there were limits of state activity in the relations of states with other states. In political theory there were limits of state activity in the relations of state to subject. In juristic theory there were limits of individual activity in the relations of individuals with each other. Grotius, and 17th century jurisprudence following him, made reason the measure of all obligation. Thus at the very time that the common law had established its doctrine of supremacy of law and had turned the feudal duties of the paramount lord toward his tenants into legal duties of the king toward his subjects, a juristic theory of fundamental imitations upon the activities of states, of rulers and of individuals dictated by eternal reason, had sprung up independently to furnish the scientific explanation. As has been said, Grotius and those who followed him made reason the measure of all obligation. They conceived that the end for which law exists is to produce conformity to the nature of rational creatures. They had broken with authority as authority, but they accepted the Roman law as embodied reason and ventured little that did not have authority behind it. Hence they accepted the Roman maxim, not to injure another and to give to everyone his due, that is, respect for personality and respect for acquired rights, as conformity to the nature of rational creatures. This raised certain obvious problems. What is injury to another? What is there in personality that makes aggression an injury? What is it that constitutes anything one's own? Grotius and his successors tried to answer by a theory of natural right, not merely natural law, as before, not merely principles of eternal validity, but certain qualities inherent in persons and demonstrated by reason and recognized by natural law, to which therefore the national law ought to give effect. Thus, again, at the very time that the victory of the courts in the contests between the common law courts and the Stuart kings had established that there were fundamental common law rights of Englishmen which Englishmen might maintain in courts and in which courts would secure them even against the king, a juristic theory of fundamental natural rights, independent of and running back of all states, which states might secure and ought to secure, but could not alter or abridge, had sprung up independently and was at hand to furnish a scientific explanation when the next century called for one. By a natural transition, the common law imitations upon royal authority became natural imitations upon all authority. The common law rights of Englishmen became the natural rights of man. Each underwent some change of substance along with this change of name. To understand this change and the effect which it had upon the law as we received it at the end of the 18th century and worked it over in the forepart of the 19th century, we must examine the theory of natural rights, the theory of the relation of law to natural rights, and the theory of natural law and of the possibility of deducing a fixed and complete system of positive law from the principles of natural law, as these theories were held when our bills of rights were framed and our constitutional law was formative. According to the Grotian definition, a right is that quality in a person which makes it just or right for him either to possess certain things or to do certain actions. The medieval idea was that law existed to maintain those powers of control over things and those powers of action which the social system had awarded or attributed to each man. The Grotian idea was that law exists to maintain and give effect to certain inherent moral qualities in every man which reason discovers for us, by virtue of which he ought to have certain powers of control over things or certain powers of action. But one of the characteristics of the stage of liberalization which may be called the stage of equity or natural law is a tendency to hold that the legal and the moral are necessarily synonymous, that if something ought to be juristically, for that reason alone it is legally. Hence the scheme of natural rights that the law ought to secure, quickly becomes the scheme of fundamental rights which it does secure, legal rights being taken to be merely declaratory thereof. There was a good side to all this. The insistence on what ought to be as the measure of what is did no less than create international law, and it liberalized and modernized the actual law of the European states through the juristic testing of every doctrine and every category with reference to its basis in reason. but it had a bad side. It led to a confusion between the interests which it is conceived the law ought to recognize and the rights by which the law secures interests when recognized, which has been the bane of jurisprudence ever since. And it led to absolute notions of an ideal development of received legal ideas as the dual order of nature, which later brought legal thought and popular political thought into an obstinate conflict. A legal system attains its end by recognizing certain interests, individual, public and social, by defining the limits within which these interests shall be recognized legally and given effect through the force of the state, and by endeavoring to secure the interests so recognized within the defined limits. It does not create these interests. There is so much truth in the 18th century theory of natural rights. Undoubtedly the progress of society and the development of government increase the number and variety of these interests. But they arise, apart from the law, through the competition of individuals with each other, the competition of groups or societies with each other and the competition of individuals with such groups or societies. The law does not create them, it only recognizes them. Yet it does not have for its sole function to recognize interests which exist independently. It must determine which it will recognize, it must define the extent to which it will give effect to them in view of other interests, individual, public or social, and the possibilities of effective interference by law, and it must devise the means by which they shall be secured. Such is the theory of today. The 17th and 18th century theory, however, confused the interest, which exists independently of law, and the legal right, the creature of law. It confused the interest, which the law recognizes in whole or in part and seeks to secure, with the right by which the law gives effect to the interest when recognized and to the extent of the recognition. Natural rights mean simply interests which we think ought to be secured, demands which human beings may make which we think ought to be satisfied. It is perfectly true that neither law nor state creates them, but it is fatal to all sound thinking to treat them as legal conceptions. For legal rights, the devices which law employs to secure such of these interests as it is expedient to recognize, are the work of the law and in that sense the work of the state. Through the exaltation of individual interests which resulted from the theory of natural rights and the confusion of interest and legal right involved therein, the natural rights of men presently became as tyrannous as the divine rights of states and rulers. It soon became apparent that the theory of inherent moral qualities, while it would serve for interests of personality, for claims to be secure in one's body and life and the interests immediately related thereto, would not serve as a basis for the so-called natural right of property, for the suum cuique element of justice, or, as we put it today, for interests of substance. None of the jurists of that time questioned the existing social order. On the contrary, they assumed as beyond question a natural right of property. They conceived that security of acquisitions, including what one had acquired through the existing social order, was a chief end. At the same time they could not but see a difference between this natural right and such rights as those to the integrity of one's body, to free motion and locomotion and to free speech. Accordingly jurists turned for an explanation to the idea of contract. It must be remembered that contract in this connection has reference to the Roman conception of a legal transaction, an act intended to have legal consequences to which the law attributes the intended result. In the 17th and 18th centuries this was the staple legal analogy. The idea of the legal transaction was the most important contribution of Rome to the law, and in an age when trade and commerce were expanding the law of such transactions was becoming the living part of the legal system. The juristic problem of the time was to reconcile the needs of business and the ethical ideas of good faith which accompanied the infusion of morals into the law with the traditional categories of contracts in Roman law. Naturally contract loomed large in juristic thought for 2 centuries. Moreover, the central point in the theory of the legal transaction is will, the will to produce a possible and legally permissible result. But the central idea in the theory of natural law and of natural rights was conformity to the nature of reasoning creatures possessed of wills. So the question, how could such creatures acquire rights against one another, seemed easy to answer. How, indeed, could this be except by contract, through a legal transaction? Thus the foundation of the natural rights, which the law existed to maintain, was taken to be a legal transaction, a compact of all men with all men, by virtue of which rights and corresponding duties were created. Justice, therefore, consisted in respecting and observing the terms of this compact, and the business of the jurist and the lawmaker was to discover and to interpret its terms. The sole end of the law was taken to be a giving effect to the inherent moral qualities in individual men, whereby things are theirs, or a securing to individual men of those things to which they are entitled under the terms of the social compact. Not only was the 18th century system of natural rights a closed, hard and fast system, for the jurists of that time were sure that they could deduce all the terms of the social compact and all the inherent moral qualities of mankind from the nature of man in the abstract. But the 18th century theory of law was no less absolute. It was conceived that there were first principles of law inherent in nature, and that these principles were discoverable by deduction as necessary results of human nature. Hence it was thought possible to discover, and that the jurists had discovered, principles of universal validity, among all men, in all places and in all times, from which might be deduced a complete code for the lawgiver, a complete constitution for the statesman, and an infallible guide to the conscience for the individual. It was thought possible through elaborate bills of rights to prescribe universal principles by which legislation might be guided for all time. Identification of the common law rights of Englishmen with the natural rights of man, and of the fundamental law for which Coke contended with the immutable and eternal natural law, had two consequences for our common law tradition. One was to give currency to an idea of the finality of the common law, for, as has always been true when men have believed in absolute theories of the sort, the principles, supposed to be the dictates of nature, flowed in practice from one of two sources. On social, economic and ethical questions, nature was always found to dictate the personal views of the individual jurist as they had been fixed and settled by education, association and, perhaps, class interest. On legal questions, nature was found to dictate for the most part the principles of law with which the individual jurist was familiar and under which he had grown up, just as in 9 cases out of 10 natural law meant for the continental jurist of the 17th and 18th centuries an ideal development of the principles of the Roman law, which he knew and had studied. For the common law lawyer it came to mean an ideal development of the common law. The past generation of lawyers brought up on Blackstone learned this mode of thinking as part of the rudiments of legal education. More recently our historical legal scholarship, assuming that all of our legal system was at least implicit in the law reports of the 16th and 17th centuries, if not in the yearbooks, gave us a natural law upon historical premises. Hence scholar and lawyer concurred in what became a thoroughgoing conviction of the 19th century, that at least the principal dogmas of the common law were of universal validity and were established by nature. When the lawyer spoke of law he thought of these doctrines. He conceived that constitutions and bills of rights simply declared them. He construed statutes into accord with them. He forced them upon modern social legislation. When he reminded the sovereign people that it ruled under God and the law, he meant that these doctrines, which he conceived as going back of all constitutions and beyond the reach of legislation, were to be the measure of state activity. This was not the true common law. The common law rested on the idea that reason, not arbitrary will, should be the measure of action and of decision. But the 18th century was sure that it had the one key to reason, and was fond of laying out philosophical and political and legal charts by which men were to be guided for all time. Examples of this idea of the finality of the common law and of the identity of its principles with the principles of natural law may be found throughout the reports of the last century. Thus in the great case of Fletcher v. Beck, where a statute of Georgia revoking a land grant on the ground that it had been procured by fraud was in question, it appeared that the land had passed into the hands of a purchaser for value without notice. This being so, Chief Justice Marshall said that, apart from particular provisions in the federal constitution, the state was restrained from such legislation by general principles which are common to our free institutions. The general principle here was the familiar one that equity will not set aside a transaction for fraud where the title to what was parted with through fraud has passed to a purchaser for value without notice. This principle depends upon the history of our courts of equity and the relation of equity to law in our system. Apart from this history, it has not seemed so intrinsically self-evident to recent thinkers. In the same spirit, At the end of the century, when legislation prohibiting employees from making certain contracts came before the courts, we find more than one laying down a doctrine of natural incapacities to which the legislature is incompetent to add new ones based merely on the facts of modern industrial employment. In the event these natural incapacities all prove to be incapacities which were recognized at common law. In the same spirit, in the present century we find an able court saying of the fellow servant rule that it is a part of the general American common law, resting upon considerations of right and justice. The fundamental conceptions of our traditional case law came to be regarded as fundamental conceptions of legal science. Not merely the jurist, but the legislator, the sociologist, the criminologist, the labor leader, and in the case of our corporation laws and laws as to restraint of trade, the businessman had to reckon with them. With the coming of a period of collectivist thinking and of social legislation, conflict was inevitable. Such a conflict did result when the absolute theory of law came in contact with an equally absolute theory of politics. While on the one hand the legal theory as to the nature of law had become absolute through the general acceptance of the 18th century conception, a political theory became established on the other hand which ran counter to the whole common law theory of law and of lawmaking. For the popular theory of sovereignty, what we may call the classical American political theory, is quite as firmly rooted in the mind of the public as the 18th century theory of law is rooted in the mind of the lawyer. The layman is taught this political theory in school, he reads it in the newspapers, he listens to it on the 4th of July and from the stump and from Chautauqua platforms, and he seldom or never hears it questioned. In consequence, he is as thoroughly sure of it as is the lawyer of his juristic theory. If the lawyer is moved to stigmatize all that does not comport with his doctrine as lawlessness, the people at large are moved to stigmatize all that does not comport with their theory as usurpation. While the lawyer as a rule still believes that the principles of law are absolute, eternal, and of universal validity, and that law is found, not made, the people believe no less firmly that it may be made and that they have the power to make it. While to the lawyer the state enforces law because it is law, to the people law is law because the state, reflecting their desires, has so willed. While to the lawyer law is above and beyond all will, to the people it is but the formulation of the general will. Hence it often happens that when the lawyer thinks he is enforcing the law, the people think he is overturning the law. While, for example, the lawyer thinks of popular action as subject to legal limitations running back of all constitutions and merely reasserted, not created, thereby, the people think of themselves as the authors of all constitutions and limitations and the final judges of their meaning and effect. This conflict between the lawyer's theory and the political theory weakens the force of law. The lawyer's theory leads him to pay scant attention to legislation or to mold it and warp it to the exigencies of what he regards as the real law. But to those who do not share his theory, this appears as a high-handed overriding of law, and the layman, laboring under that impression, is unable to perceive why the lawyers should have a monopoly of that convenient power. On the other hand, the people's theory that law is wholly a conscious product of the human will tends to produce arbitrary and ill-considered legislation impossible of satisfactory application to actual controversies. Each of these absolute theories must be given up. A second effect of 18th century theory upon the common law tradition was to intensify the individualism of which for other reasons it had quite enough. In both its aspects the juristic theory of natural rights was thoroughly individualist. As a theory of inherent moral qualities of persons, it was based on deduction from the nature of an abstract isolated individual. As a theory of rights based upon a social compact, it thought of natural rights as the rights of individuals who had entered into a contract, apart from which there would and could be no law and nothing for the law to maintain. In either view, the law exists to maintain and protect individual interests. This fitted the legal theory of the common law rights of Englishmen so perfectly that there is no cause for wonder that the founders of our political and legal and judicial systems, who were studying Coke and Blackstone on the one hand and the French and Dutch publicists on the other, thought they were reading about the same things. Hence Americans of the end of the 18th century argued for either or for both. The Declaration of Rights of the Continental Congress of 1774 asserted the legal rights of Englishmen. The Declaration of Independence of 1776 asserted the natural rights of man. Yet each claimed essentially the same things. It followed that the common law was taken to be a system of giving effect to individual natural rights. It was taken to exist in order to secure individual interests, not merely against aggression by other individuals, but even more against arbitrary invasion by state or society. It followed also that the Bills of Rights, declaratory of natural rights, were likewise declaratory of the common law. This idea is very prominent in judicial discussions of liberty of contract in the 19th century. For example, one court in passing on legislation directed against fines in cotton mills, tells us that a statute which violates fundamental rights is unconstitutional and void even though the enactment of it is not expressly forbidden. Another court tells us that natural persons do not derive their right to contract from the law. Hence whatever the state may do in limiting the power of a corporation to make certain contracts, because the corporation gets its power from the state, it may not limit the contractual capacity of natural persons, who got their power to contract from nature, so that nature alone may remove it. Another court, in passing adversely upon legislation against company stores, said that any classification was arbitrary and unconstitutional, unless it proceeded on the natural capacity of persons to contract. Another, in passing on a similar statute, denied that contractual capacity may be restricted except for physical or mental disabilities. Another held that the legislature could not take notice of the de facto subjection of one class of persons to another in making contracts of employment in certain industries, but must be governed by the theoretical jural equality. All these instances come to the proposition that the common law categories of disability are final and that legislation may not add new ones. The Bills of Rights and the 14th Amendment were treated as but declaring a natural liberty which was also a common law liberty. Hence an abridgment not known to the common law was thought to go counter to their fair construction, if not to their letter. Perhaps nothing contributed so much to create and foster the hostility to courts and law and constitutions, which was conspicuous at the end of the 19th century and at the beginning of the present century, as this conception of the courts as guardians of individual natural rights against the state and against society, of the law as a final and absolute body of doctrine declaring these individual natural rights, and of constitutions as declaratory of common law principles, which are also natural law principles, anterior to the state and of superior validity to enactments by the authority of the state, having for their purpose to guarantee and maintain the natural rights of individuals against society and all its agencies. When houses are scarce and landlords are grasping, Blackstone's proposition that the public good is in nothing more essentially interested than in the protection of every individual's private rights is not the popular view. A crowded, urban, industrial community looks to society for protection against predatory individuals, natural or artificial, and resents doctrines that protect these individuals against society for fear society will oppress them. But the common law guarantees of individual rights are established in our constitutions, state and federal. So that, while in England these common law dogmas have had to give way to modern legislation, in America they have stood continually between the people, or large classes of the people, and legislation they desire. In consequence, the courts were long put in a false position of doing nothing and obstructing everything, which it was impossible for the layman to interpret aright. It is not in constitutional law alone that the common law rights of Englishmen, translated into rights of man and entrenched in constitutions, have been a source of popular irritation toward the law. American criminal procedure has done scarcely less to produce discontent with judicial administration of justice. But judicial administration of punitive justice is hedged about on every side with constitutional guarantees securing the so-called natural rights of the accused. All crimes of any consequence were once felonies punishable with death. The reform that led to milder sentences and more humane punishments came after the principles and even the detailed rules of criminal procedure had been well established. The judges favoring life in capital cases, and all cases of any consequence were capital, took advantage of the slightest technical defect to discharge a defendant, and form became in the highest degree essential. When the common law rights of the accused Englishman became the natural rights of the accused man and these rights were entrenched in state and federal constitutions, These rules and the spirit in which they were conceived were projected into a time in which they were not merely inapplicable but downright harmful. Bentham long ago pointed out the ill effects of the complicated, expensive and time-consuming machinery of a common law criminal prosecution. Many states, however, guarantee to an accused the power to insist upon all of this wasteful machinery as a natural right which legislation must hold sacred. Again, another serious defect in our criminal procedure is the lack of any legal mode of interrogating the accused. In practice, the rich malefactor takes the advice of counsel, closes his mouth and leaves the prosecution to prove what it may. The police labor with the friendless malefactor till a confession is extorted. Let us note how the privilege of the accused against interrogation and the rules of evidence as to confessions arose. When these institutions of the law grew up, petty offences against property were felonies and the offenders were peasants and labourers, habituated by generations of subordination to an exaggerated, one may say a stupid, deference to authority. As Dean Wigmore has said, in commenting upon the rules as to confessions, the situation of such a peasant, charged by his landlord with poaching and urged to confess, the situation of a maid urged and threatened by her mistress to confess a petty theft, involves a mental condition to which we may well hesitate to apply the test of a rational principle. We may believe that rationally a false confession is not to be apprehended from a normal person under certain paltry inducements or meaningless threats, but we have here perhaps a person not to be tested by a normal or rational standard. It is not to be wondered at that the judges of 150 or even 100 years ago strained every point to exclude confessions and prevent interrogation of accused persons. But under modern conditions of an emancipated proletariat fully conscious of its rights and filled with scant respect for authority, the whole basis of these rulings has failed. And today the immunity from interrogation and the strict rules as to confessions do the poor no good and are an unnecessary burden upon the prosecutor. Immunity of accused persons from all interrogation, if they are firm, well advised and able to give bail, is a most effective shield of wrongdoers. Knowledge of this tempts police and detectives and prosecutors to lawless modes of getting what cannot be had lawfully whenever the poor and defenseless are in their custody. Granting all that may be said as to the abuses to which a legal form of interrogation is liable, the fact remains that the present state of the law operates unequally and invites oppression and lawlessness. No rich man has been subjected to the third degree to obtain proof of violation of antitrust or anti-rebate legislation, and no powerful politician has been so dealt with in order to obtain proof of bribery or graft. The common law right of the accused poacher, become the natural right of the accused magnate and entrenched in the Bill of Rights, shows how legal machinery may defeat its own ends when one age conceives it has said the final word and assumes to prescribe unalterable rules for time to come. Lawyers of the last century were brought up on the doctrine of natural rights and the conception that law exists to secure these rights to the individual as against state and society, as fundamental doctrines. They were brought up to believe that the highest social interest was an interest in securing to everyone these natural rights. Inevitably they regarded protection of the supposed right of the accused to every jot of procedural advantage afforded him by a ritual born of obsolete conditions as a duty superior to protection from lawlessness, since the first interest of the public lay in maintaining that same right. Thinking of common law rights as declaratory of natural rights and of common law doctrines as declaratory of natural law has led to bad results also in the attitude of courts toward legislation. The courts have done more than enforce their ideas of economics upon reluctant communities and passing upon the constitutionality of social legislation. Through their power of interpretation they have made statutes yield to their juristic ideas in the very teeth of legislative intent. Usually they have done this from belief in the eternal and unalterable character of common law doctrines and common law institutions. Conceiving some doctrines to be beyond the reach of legislation, they have held that statutes were meant only to reaffirm and declare these doctrines and not to introduce anything new. Conceiving that case law is the normal type and legislature made law something exceptional, to be resorted to only on special occasions and for special reasons, they have insisted that we must presume the legislature intended no innovation upon the common law, must construe strictly all departures the form, and must restrict the operation of changes to those particulars with respect to which the statute is clear and express. Bearing in mind that the common law thus protected so zealously from all modification is essentially judge-made, these doctrines certainly come very close to a judicial assertion of legislative incompetence to deal with ordinary legal relations. To take another example, if a state legislature acts unreasonably and arbitrarily in the enactment of an oppressive statute, the courts conceive that there is a deprivation of liberty or property within the purview of the 14th Amendment, and the federal courts, if necessary, will refuse to give effect to the enactment or will even restrain its operation. If the state executive acts unreasonably and arbitrarily to the injury of an individual, the same position will be taken. The act is fairly certain to be held of no effect. But let the state judiciary act in the same way, and the divinity that doth hedge about a court requires a different result. If the highest court of a state decides arbitrarily and unreasonably in defiance of all legal principle, there is no remedy. The protection which the 14th Amendment throws around liberty and property when they are threatened by legislative or executive action is withdrawn. In such a case our highest federal tribunal will not act. One need not complain of these propositions. It is enough to state them as facts. Whether the doctrines are desirable or undesirable, they demonstrate that judges, like the king and like the people, when they act upon absolute theories, are not easily confined by self-imposed limitations and may even wield absolute power in an arbitrary manner. Probably of the three they are on the whole least likely to do so. For the training and bent of judges leads them to subordinate everything to principles and general rules. Even when they overstep legal bounds, they do so according to rules and upon a system. Their theory is that some rule or principle contains a better expression of the law. But a theory must be judged by its fruits. One under which so many of our state courts in the last century made of the proposition that statutes will not be held unconstitutional unless their repugnance to the Constitution is beyond doubt a mere courteous and smoothly transmitted platitude is worse than an anachronism. But we must not infer that the contribution of 18th century theory to our legal tradition is to be cast out utterly, for the theory of fundamental principles to which law must conform and of fundamental interests which law must secure at all events has another side. Those who held it were willing to do justice and to suffer justice to be done against their immediate interests for the very sake of justice, and they were eager to vindicate justice at any cost. Where the 18th century and the 19th century American were willing to bear a hand in the administration of justice by asserting rights even at a sacrifice, today vindication of right and justice are generally, if not universally, coming to be secondary to the trouble and expense involved. Where the common law relied on individual initiative, we are more and more turning to administrative interference. No doubt the delay and expense in litigation involved in our judicial organization has had much to do with the one phenomenon, and our excessive reliance on individual action and the requirements of large cities, of the relation of employer and employed in modern industry and of distribution in a highly specialized society have had much to do with the latter. But beyond what may be assigned to these causes there has been a marked change. The administration of justice, said Daniel Webster, is the great end of human society, and he pronounced justice, meaning the end of the legal order, the greatest interest of man on earth. In contrast with such statements, which were staple in the last century, men are saying today that material welfare is the great end to which all institutions must be directed and by which they must be measured. Men are not asking merely to be allowed to achieve welfare, they are asking to have welfare achieved for them through organized society. Much that advertises itself as social is in truth individualist. It is individualism to be attained through society rather than through individual self-help. Even though we seek social ends through law, law is not self-enforcing. Except as a vigorous despot may for a time put rules in force by the might of his arms, enforcement depends ultimately upon the general will. And this does not mean an abstract desire that a rule or a body of rules be adhered to. It means a steadfast will on the part of the individual citizen to obey the rule in action and to see to it that others obey it also. An active individual popular interest in justice, a fixed and constant popular determination to secure, For everyone his due is a prerequisite of an effective legal system. The law may give effect to this determination. It cannot create it. An easygoing attitude toward right and justice bodes as ill for law as an easygoing attitude toward politics bodes ill for government and administration. The individual citizen must do his duty with respect to the one no less than with respect to the other, if the machinery of the modern state is to be effective. Moreover, even if we grant that ultimately all interests, individual and public, are secured and maintained because of a social interest in so doing, this does not mean that individual interests, the details of which the last 2 centuries worked out so thoroughly, are to be ignored. On the contrary, the chiefest of social interests is the moral and social life of the individual, and thus individual interests become largely identical with the social interest. Just as in the 17th century an undue insistence upon public interests, thought of as the interests of the sovereign, defeated the moral and social life of the individual and required the assertion of individual interests in bills of rights and declarations of rights, there is like danger now that certain social interests will be unduly emphasized and that governmental maternalism will become an end rather than a means and defeat the real purposes of the legal order. Although we think socially, we must still think of individual interests, and of that greatest of all claims which a human being may make, the claim to assert his individuality, to exercise freely the will and the reason which God has given him. We must emphasize the social interest in the moral and social life of the individual. But we must remember that it is the life of a free willing being.